this is comprehensive and concise. I think Professor Stein is the foremost expert on Asia in Norway, but you're also showing today that you're foremost expert on Norway and Scandinavia in Asia. Yeah, comprehensive and also up to date. I didn't realize it just last week that you went through these amendments. So very, very up to date. Now we turn to some reflections on Thailand. We've had a number of constitutions in Thailand. A couple of points here. One, Ambassador Katja mentioned earlier about slicing the pie. How the pie has to grow and how it has to be sliced in such a way that it keeps the peace and stability and maintain the prosperity and so on. And the other is that, when constitutions are written, it's important that it's not written in emergencies. So in your case, and I think in the US too, to a degree, constitutions are written, when they have a good time to think and to contemplate, to argue and debate. When constitutions are written in emergency situations, I think we have, in a lot of countries we have that, certainly in Thailand. So our constitutions in Thailand, we've had a number, I think 18, is it 18? Yeah. So normally these 18 constitutions are written against something. The most successful constitution, the most appealing to us has been the 1997 constitution. I don't have it with me, but now it has been superseded, replaced by the 2007 constitution. But both also were written against something. The 1997 constitution in Thailand was written against the vicious cycle of money politics, of having politicians, elected politicians in government engaging in corruption, leading to a loss of legitimacy, laying the way for a military coup, and then a new constitution, and it begins again with election and so on. And that money politics vicious cycle led to the 1991 military coup and to the 1992 violence between the military and the protesters in Bangkok. And for the first time, that was an organic time in 1992. We felt, I think, Thai society, that we had to come up with a constitution that would once and for all get rid of this vicious cycle, and once and for all lay the basis for a constitutional monarchy, minimizing corruption, promoting stability and effectiveness of government with separations of power and checks and balances and so on. So the idea was to have a more stable and effective government. And another main idea was to have a more transparent and accountable political system. So we had things like, for the first time, senior officials, politicians had to declare their assets. That was very important. So the idea is that if your assets increased over time that you're in office, then it must not be honestly derived, and so on. So these are the mechanisms that we tried through trial and error, and we're still, I think, evolving. And I think Norway is also evolving, if you had amendments in recent days. So we have a lot of reflections. I think we will now come to our panel speakers to reflect on the Thai experience. And when you talk about the Thai constitution, you really are now talking about Thai politics. And we have very spicy politics this week and in the last 6 months and the last 10 years, 14 years, and even longer. Let me first invite Prajadhipok-Pitch Pongsawat, my good colleague from the faculty. He teaches Thai politics, in fact, at the faculty. He has a PhD from Berkeley, and he's written many articles and so on. You can see his CV in the materials that have been passed out. But Prajadhipok is also an anchor personality for Voice TV. Every morning he does his show, which is very popular on Voice TV. It's called Wake Up Thailand, right? Wake Up Thailand, with 2 other anchors. And they've been stimulating, provocative, addressing current events, controversial topics. He also has written newspaper op-eds and so on. So Prajadhipok, please, the floor is yours. What do you think about Thai constitutionalism? Why have we had so many constitutions? When will we have the last one? And what will happen next?
I will divide my talk into three parts. The first part will be on reflection on the presentation of the Norwegian constitution and politics, just a little bit on that. Then the second part will be on an overview of how the Thai scholars approaching the constitution, the way we taught constitution and the way we deal with constitution. And the third part will be the reflection on the so-called Thai constitutionalism. Okay. The first part on my reflections on the Norwegian constitutions and the story around the constitutions. It seems to me that political history and political geography of Norway matters a lot. As what you said, right? You're surrounded by a lot of basically a big empire, right? Especially the way you have to deal with the Swedish empire. And that's what you said, that it makes the constitution as the one of the key identity, the political identity of Norway. But I'm not sure that's actually happened in Thailand, right? The way we treat constitution as the political identity. But actually, when we first adopted, or when we made the revolution and we first adopted the constitution, the issue of independence was one among the 6 principles of the People's Party as well. So the origin of the Thai constitution had something to do with the position of Thailand in the context of international world as well. However, the issue of the relationship between peoples, the monarchies, and constitution seems to be the key of the constitutional monarchy. And let me end this part by mentioning about one of the things I really like about the way you celebrate the Constitutional Day, right? It is from Wikipedia though. And what they said is that a notable feature of the Norwegian Constitutional Day celebration is the virtual absence of any military parades, the day being almost wholly a civilian celebration. So that's one of a very interesting issue that I couldn't catch up on the presentation, is the role of the militaries into politics, given the fact that it's such a long history, right? And how the peoples, the constitution deal with the influence of the militaries. And also I'd like to add into a little bit of this story that I think the Constitutional Day is a national day, right? In Norway. In Thailand, we got the Revolution Day, 24th of June, as the National Day in 1938. And then in 1960, when the military authoritarianism took power, he changed the constitution, the National Day, into the King's birthday. Interestingly, he made a good excuse that to follow the tradition of constitutional monarchy, countries like England, Japan, and Denmark, that the country with the constitutional monarchy should celebrate the National Day by celebrating the King's birthday. Okay, so that is very interesting. My second part is to give you an overview. I mean, I imagine this is the first round, but I'm going to talk about the way Thai academic deal with constitutions. There's actually 6 way of dealing with the constitution and teaching the issue of constitution. The first one the oldest one is to look at constitution in a kind of like political philosophy way of and comparative government. So you believe that reading the constitution is to understand the polity of that country, very formalistic way. So what appear in the country is the thing that written in the constitution, which in fact probably not true. But in the old day, before the Google time, before the Wikipedia time, right, the way we study other country or the way we think about our own country is to look at the written constitution, right? So believing that what's written is real, okay? And that's the first group of the way we look at constitution. So then we always complain by the end that what we written is not real, especially in the old day, the section on human rights. It's always there. It's never been really implemented. So that's kind of like, this is an anecdote from the classroom that, we study all good things about the constitution and we always comment that it's not real. Second one is the practical one. It's like started in around 1980s. Ajahn Sujit was one of that movement. So we look at constitution as a tool for political development. So we really think that constitution is the tool to fix something. That's what you said, right? So we analyze the country that, we got a lot of turmoil in the 70s. So political stability was the key. So we should write the constitution to address the issue of political stability. The result was, we should engineer the constitution in such a way that we would develop political party as the key institution. And I think that traditions still practice a lot. We have always a de facto position of the Dean of Political Science at Juฬາand Thammarat to become the drafter of the constitution. Okay, from Professor Gamon, Professor Sujit, Professor Charas. So I'm not sure about the next constitution, whether the deans will be assigned to be part of the official drafter committee or not. But that's the tradition of looking at the constitution as the tool to fix something. Then 1997 was another pressing issue, right? Pani politics, as Professor Titinan said. 2007 was another pressing issue of how to prevent Thaksinism, okay, populism, those kind of things. So it's like we got a big pressing issue and we believe that constitution will fix it. And then we have a panel of our experts who try their best to come up with an interesting model from Germany, from France, from America, and think about it as a machine to fix something. The third way of looking at the constitution in Thailand is to look at constitution not as a document or as a tool, but as a reflection of the real power struggle among different groups. This is more from the Thammarat School of Professor Sane Jamarik, the founder of the National Human Rights Committee in Thailand. So he really looked at constitution as a document that reflects who has the power during that time. But he also looked at how the human right has not been the big issue. So he said, well, because it's the constitution has always been the document to reflect the political struggle. So who has power is the one who wrote the constitution. The fourth one is more into the 1997 political reform. So constitution is, we started to import the concept of constitutionalism for the first time. Okay, so we look at constitutionalism in an American way of a document, a kind of a principle to control the state power. And unfortunately, the state power during that time was occupied by, was dominated by the rural politician, the corrupted rural politician. So the 1997 was the Thai way of political constitutionalism. The fifth one, before the last one, is that there's also an increase in the study of constitutionalism after 1997. on the one hand, the issue of political economy came in, looking at the cost of people who try to utilize constitutions to enhance their right, and they say even though 1997 constitution was very good, but still very costly for people. For example, it's difficult for them to get together to like 50,000 people to initiate the law. Okay, and also the analysis of class bias in the constitution itself, right? That 1997 was very in favor of the middle class in the city as a result of the way that they came up with the concept of party list to strengthen the vote of the city's people, and also the bias for the strong government. Okay. The other one in this group of study is a post-1997 study, is from the political culture school, looking at constitution and the unwritten part of the constitution. Right? Military or the role of the monarchy has never been written clearly in the constitution, but always the key institution in the so-called unwritten constitution of Thailand. So that's the main approach. And the last one is what I call the neo-constitutionalism. That's what happened now in Thailand. The key issue is different than the 1997. Okay, the 1997, there was a different mindset that political reform during that time was more into favoring the strong government. Okay, even though they want to control the government, but they also in favor of strong government. But the product of 1997 was Thakssinism, right? You got a very strong government, very accountable for the people in a sense that he delivered what he promised. But what he promised was a populism, and it's actually got into a big crash with the neoliberalism and the middle class in the city, and always the excuses of corruption. Okay. But what happened now is that the cry for new reform that I think Ajahn Charat will tell you in more detail, and I'm very curious what actually Suthep talked with the Senate last week, right? What kind of the political plan on that. But anyway, it's an interesting, because let me move to the last point. There was a speech by one of the red shirt, the supporter of Thaksin, a few weeks ago. He said, well, the world changed very fast, and now the red shirt has to defend the current constitution, trying to make a reference to this constitution in order to protect the electoral democracy, which is, in fact, this constitution came out of the coup that overthrowing Thaksin. Right? But in fact now, those people who've been suppressed, and during the time that they made this new constitution in 2007, there was half of the country was under the martial law. Right? And there's a lot of information saying that, oh, you should accept it, you should make the referendum for the current constitution first, and we can amend it later. Right? But one side of the political party cannot amend anything, right? But then they have to uphold this constitution today in order to protect the electoral right. In fact, this constitution is not friendly to them at all. But right now, I mean, it's a practical need for them to uphold the constitution. Why many of those who actually in favor of this constitution trying to say that, hey, we need a reform, even though they don't say that we have to change the constitution, but it's an implication that this upcoming reform has something to do with the amendment of the constitution. And last point, I think what we're facing in Thailand is actually the legitimacy crisis. In a funny word, it's the fight between the traffic cone and the ballot box. Right? So we are not so sure that what is actually the role of the Constitution now, right? Because maybe 2 weeks ago we believed that Constitution is very important and the judgment of the Constitutional Court must be very important, right? And finally the Constitutional Court disqualified Yingluck, disqualify 1/3 of Yingluck cabinet. But then the Constitutional Court still keep 2/3 of the cabinet. So now it's a practical political struggle that, well, they have to force the cabinet to go out. Right? When then they cannot say that the cabinet is unconstitutional anymore, but they say they're not legitimate. Right? So now the struggle on the street has nothing to do with making a reference to the unconstitutionality of the government anymore. Right? Now it's something else. And no one actually bring the case to the court anymore, asking the Constitutional Court to rule out whether the rest of the cabinet should be unconstitutional or not, right? So now the Constitutional Court is out of the game. The Constitution is out of the game, and those anti-electoral democracy groups make a reference that, hey, you should not stick to the law that much. Right? Let's sacrifice for the sake of the nation. So the point of reference change again. Okay, I'm not saying that they're right or wrong, but I'm saying that the Constitution is no longer the source of legitimacy, a sort of reference of the anti-electoral democracy group anymore. Okay. One last comment. The last comment is that, well, the monarchy in Thailand, right? Nobody really talk much about the monarchy right now. Sometimes they make a big claim that, well, the Article 7 is important to fight for, right? But so far, I see any real attempt of those people who make a claim that Article 7 is the solution, that they really dare to propose the name or really dare to see the king. Right? So let me end this comment for this first round here.
Legitimacy crisis, I think that's a good way to encapsulate what we are going through. I do think that the constitutional struggle is still in place. The insistence is that if the government is out, then there is a vacuum, then Article 7 can be applied. So now I think they're trying to go around that in order to find a way to enact the protesters, the PDRC, Article 7. Okay, let me just move on to Dr. Michael Nelson. Dr. Nelson has been...
Don't have...
Okay. Dr. Nelson has been a visiting scholar with us at the faculty before. He is currently the lecturer at the Walailak University in Nakorn, Thammarat. And he's done a number of papers, including, I think, a paper that we're passing out today, most recently published in Contemporary Southeast Asia on Thai constitutionalism. He has a PowerPoint presentation, so just bear with us for a minute and we'll get the screens going. Dr. Nelson.
Okay, thank you very much, Ajahn Thitinan. It's sort of strange to be sandwiched between two very polar opposites in the Thai public discourse on constitutionalism and politics. So I will be speaking as a neutral person, as an outsider. What I like the presentation by Ajahn Tønnesson very much, and at the beginning he mentioned something very important. I think that is, everything was important, but to me as a German and as an observer of Thai constitutionalism, he mentioned two things. One is constitutions to be written in emergency situations, maybe leading to the fact that a faction will seize power in the constitution and impose this constitution on the rest of the country, which would lead to power struggles in order to change the constitution later if other factions assume power. In Germany, actually, I'm German obviously, in Germany our constitution was drafted decidedly in an emergency situation, namely after the disaster of the Second World War and Hitler's regime. But nevertheless, our constitution drafting at that time, with the friendly help of some foreign countries such as the US, the British, the French and the Russians, was decidedly a collective effort. So there was not one single faction that would draft a constitution towards its own advantages, but it was a collective effort to try to come up with a viable constitutional framework for future German politics. And as you all know, this constitution has been very durable since 1949 with a few amendments, but basically people agree with this document. My talk will be about the element of factionalism in your talk. Actually, this topic came to me when I was still considering what I should be talking about today. And then I was helped by a very unexpected corner, actually, what Ajahn Pitch just mentioned, namely the Thai Constitutional Court. That is on the Thai Constitutional Court on May 7, 2014, decided that Prime Minister Yingluck had to leave her office for the reason that she, as a politician, had unduly interfered into the affairs of permanent and paid civil servants. And as we all know, at least since 1991, such behavior can even lead to, I see it comes. Can you please? Okay. Actually, I have I just do the slideshow mode, please. It's okay.
Okay, good.
Okay. Okay, that's the first one. Then we go to the second one. Thank you. Where was it? Okay. So since 1991, at least, we know that interference into undue interference into the work and the affairs of permanent and paid public officials can even be used as a reason to stage a military coup d'etat. I will leave technical and legal details of the Constitutional Court verdict aside, but just point out that essentially what the court did was to discount the value of what is stipulated in the first sentence of Article 3 of the Thai Constitution of 2007. This sentence says, "The sovereign power belongs to the Thai people." When we look at this from the elections of 2011, we will notice that at that time about 35 million members of the sovereign had participated in making Yingluck Shinawatra the prime minister, be it in favor of her or be it against her. In 2014, however, rather very insignificant actions by this prime minister regarding two senior civil servants were sufficient to negate the sovereign's expressed will and force the prime minister from office. Therefore, what we are confronted with, and which the paper will be about, is who actually is a real owner of sovereign power in Thailand, the people as stated in the constitution, or the various branches of the Thai bureaucracy. In fact, I think that we are in a situation of constitutional contestation between these two sources of legitimate power. The old powers, that is, the military, the civil bureaucracy, the judiciary, and actors in the wider realm of the monarchy, are trying to fight back the new powers, that is, the people, political parties, and politicians. Among the 35 key drafters of the 2007 Constitution, appointed in the wake of the coup of September 2006, we find 15 high-level legal bureaucrats and judges, 4 conservative lecturers of law, 4 high-level bureaucrats, and 4 conservative academics, as well as 1 person with a background in political science and a few other people. Surely this group, representing the entrenched establishment, variously called, for example, by Ajahn Anik Lau Thammarat Apichon, or by the red shirts Ahmad, would not let this golden opportunity pass them by to tighten the screws on the unloved politicians. Rather, the establishment figures on the Constitution Drafting Committee, CDC, tried their best to make the scale of sovereignty tip in their favor. Let me briefly mention 3 areas in which they tried to do this. The first one, as you might guess from the slide already, the CDC tried to counter the sovereignty of the people as expressed in the House of Representatives and the government, with an upper house as expression of the sovereignty of the bureaucracy. For this purpose, a tiny selection committee comprising 7 senior bureaucrats was devised to recruit members of the Senate. As you will know, this attempt by the bureaucracy to set up their very own representative assembly to counter the popularly elected House was only partially successful because of obvious public opposition. Nevertheless, the CDC did get away with making the Senate a body selected by 7 high-level bureaucrats, as shown in this slide. It is the President of the Constitution Court, the chairpersons of the ECT, Ombudsman, National Anti-Corruption Commission, National Audit Commission, and 1 judge each from the Supreme Court and from the Supreme Administrative Court. And this then led to the attempt by the Yingluck government to push through an amendment to the 2007 Constitution in order to return to a fully elected Senate, only to be blocked by some of the very same hardliners on the CDC who had wanted a fully appointed Senate, now in their new positions as Constitution Court judges. It is those who wrote the Constitution essentially had to come up with a verdict against an amendment of their own constitutional achievement. And ironically, as we have seen in the past week, the appointed senators seem to have been eager to provide us with arguments for abolishing appointed senators once and for all. The second area, the CDC tried to cut back non-bureaucratic participation and indeed entered into what has been called judicialization of Thai politics, concerns the independent constitutional organizations, that is the Constitutional Court, the Election Commission, the Ombudsman, the National Anti-Corruption Commission, the Audit Commission, and the National Human Rights Commission. As you may recall, these organizations were made an essential part, and I think Ajahn Pitt just mentioned that, an essential part of the 1997 Constitution with a purpose to erect some sort of fence around the politicians in order to control their behavior. You can see this in the slide. On the left-hand side, you have the political area, electoral politics, then you have the selection committee, and then you have the Senate. That is, this non-political Senate at that time was an essential part of this design because it would make the final decision about the members of these independent organizations and then submit their names for the king's signature. However, the Senate could not act alone. Rather, selection committees would carry out the main recruitment task. The CDC of 2007 did not change this basic design of the 1997 Constitution, but it substantively changed the composition of the recruitment committees by eliminating non-judicial members from the selection committees, as you can see in the next slide. So on the left-hand side, these are three examples: Constitutional Court, Election Commission, and the National Anti-Corruption Commission. In 1997, we had one judge in the committee to determine members of the Constitutional Court and 12 others. That has changed in 2007 to 2 judges and 1 person from the independent organizations to 2 others, namely the opposition leader and the House Speaker. What you can see under others for 2007, 2 is always the House Speaker and the opposition leader. Election Commission has changed from 2 judges to 8 others, to 5 judges and 2 others. 1997, NACC 3 to 12, now 3 to 2. So one example would be the Constitutional Court. You can see that in 1997 there was just 1 judge, and then 4 deans of faculties of law, 4 deans of faculties of political science, and 4 members of parliament. That's all gone. We now have the President of the Supreme Court, President of the Supreme Administrative Court, House Speaker, Opposition Leader, and 1 President of independent organizations. In short, the majority of judicial officials and legal experts on the Constitution Drafting Committee had used the military coup-derived opportunity to seize the decisive power in determining which people would be appointed to the independent constitutional organizations. The late respected human rights lawyer Tongbai Tongbao, when seeing who the selection committee had named to sit on the new National Human Rights Commission, wrote an article headlined, National Human Rights Commission selection is deeply flawed. I quote, "All in all, the selection process proves true that, yet again, that aristocrats and/or officials do the screening. We can count on them picking candidates of the same kind. The sad part is that there was no lack of constitutionally qualified people to choose from. Many of the original 133 applicants for the commission do have active roles in human rights as labor leaders, women's rights defenders, leaders of private human rights commissions, etc." So that was a very much distorted outcome in determining the members of the National Human Rights Commission in favor of members who are closely connected to establishment forces. The third issue I would like briefly touch upon in order to show how the drafters try to fundamentally undermine the sovereignty of the Thai people is the long section in the 2007 Constitution on directive principles of fundamental state policies. Now, such sections have long been part of Thai constitutions. As far as I remember, the first one was in 1949, and the 1979 Constitution and the 2007 Constitution are no exception in this respect. However, the drafters of the 2007 document made a decisive change over the 1979 version, as you can see in this slide. In the 1997, on the left-hand side, the constitutional determination of fundamental state policies were non-binding guidelines to be monitored by the newly established National Economic and Social Advisory Council. The drafters of the 2007 Constitution went much further than this. They acted like a pseudo-political party, putting together a policy platform for an election campaign. But they did not want to present this platform to the voters in elections. Rather, the CDC set out to force any elected government to implement what they thought were good policies for the country. For this, a cabinet had to declare in Parliament how and in which time frame they would implement these constitutionally stipulated policies, and the cabinet was also mandated to draw up a national administration plan for the implementation of these policies, as well as a legislative plan. At the time of drafting the 2007 Constitution, I closed a talk at the FCCT with the sentence, "This approach and the details amount to an attempt to undercut the importance of elections in reaching collectively binding decisions, and instead turn Thailand's elected government into a bizarrely bureaucratic monster." But there was an even more damning verdict by another commentator, that is Chang Noi, who said, I quote, "This is an attempt by a handful of charter drafters to dictate policy. A fundamental principle of parliamentary democracy is that policy making is a duty of elected representatives who are in some way responsible to their constituency. This chapter betrays the drafter's total contempt for the principle of parliamentary democracy." End of quote from Chang Noi. Before Chang Noi came to this conclusion, he had actually taken a swipe at the name of this chapter in the Constitution, Directive Principles of Fundamental State Policies, by noting, "If you think that the title has a whiff of documents emerging from the Supreme Council of some totalitarian state, you might have the right idea." That sounds quite nice, but I'm a German, and so as a German, I'm closer to my previous famous fellow German, Karl Marx. Karl Marx had issued the famous dictum that states are merely the managing committees of the ruling capitalist bourgeoisie. So in this case of the Thai 2007 Constitution, the government, the elected government, was transformed into some kind of the managing committee of the Thai bureaucracy. These three issues concerning the sovereignty of the Thai people are actually embedded in a more fundamental kind of constitutional contestation. This is about the competitors that the Constitution has to struggle with in the political order. Please have a look at this slide. It's supposed to illustrate that the Thai political order is not a unified system that finds expression in a constitution that covers the entire political system. Rather, the Thai political order comprises two competing models. On the left-hand side, we have the components of the old hierarchical system, while the right-hand side shows the components of the new democratic constitutional order. As you can see, the highest value in the old system, that is the official state ideology of nation, religion, and monarchy, directly collides with the highest value in the new system, that is the constitution. This perhaps becomes a little bit clearer in the following slide. What you can see here is that the key elements of the state apparatus, be it the military, the civil bureaucracy, or the judiciary, provide the foundation of those three pillars, nation, religion, and monarchy, that carry the weight of the existence of the eternally sovereign Thai nation. In this understanding, the bureaucracy, that is the establishment, Apichon or Amat, however you might want to call them, could not care less about the sovereignty of the people. These people are far from being the sovereign basis of the Thai nation. Rather, the people merely fulfill the position of assistants of the state apparatus in carrying the three pillars. Nevertheless, this hierarchical model, as I had said previously, has substantially been perforated by the increasing weight of notions such as democracy, political parties, voters, politicians, political representation, all centered around the new value of the constitution. The realization of Thai constitutionalism, then, requires that all actors in the political order accept the sovereignty of the people and adhere to the key features laid down in the Constitution. The process of the drafting of the 2007 Constitution, much of its content, and the fact that many actors in the current political turmoil have chosen deliberately to ignore, violate, or distort the 2007 Constitution, most importantly, including an outrageous denial of the people's sovereignty and their basic political rights, proves that constitutionalism in Thailand remains an ideal to be realized only at some more or less distant point in the future. Thank you very much.
Thank you, Dr. Nelson. That was direct to the point. I think we will have the presentation will also be available on the ISIS website. Now, the narrative, we can say that the narrative for us in Thailand is that the pendulum has swung one way to the other side and it has swung too far. And now we are struggling with how to swing it back to a new balance of some kind. So the 1997 Constitution was a very popular constitution. It came from a genuine grassroots organic effort to try to eradicate money politics and so on. So it came up with a charter that was at that time very appealing. It had nationwide support. In fact, the people who did not like the 1997 Constitution were the politicians, right? But then the 1997 Constitution proceeded, and it was eventually penetrated and captured by the Thaksin party machine. The 1997 Constitution achieved its objectives. It had a very strong government. First government that lasted a full term, a one-party government, 2005, a prime minister that completed a full term. But then it was so strong, and the backlash against it from 2006 we've seen has gone so far in one direction. And now we have the ironic situation that John Pitt has mentioned, that now the defenders of the 2007 Constitution are actually the victims of the military coup in 2006. So it's a very ironic kind of dilemma that we have